The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. 4 cases will be submitted to the court this afternoon. Those cases are the State of Mercedes Gottschalk versus Pomeroy Development and Pomeroy Care Center. Second case is State of Iowa versus Janelle Coleman. The third case is Paula Segura and Ricardo Segura versus State of Iowa. And the final case is Blake Jacobs versus Iowa Department of Transportation. The final 2 cases will be submitted to the court without oral argument. We will now hear the arguments in the Gottschalk case. Mr. Hamilton.
Please the court, Mr. Chief Justice, Associate Justices. My name is Willis Hamilton. I am here. We're going to split time, Mr. Luginbill and I'm going to try to take 10. He's going to try to take 5. And since he is the enemy of my enemy, he is my friend today. So to begin with, this, of course, is a request for further review from an adverse ruling by the Court of Appeals, who sustained a motion for summary judgment dismissing the State of Iowa from this case. The case originated when a lady by the name of Mercedes Gottschalk, a 93-year-old retired farm wife, was sexually assaulted in the Pomeroy Care Center in Pomeroy, Iowa in August of 2011. The perpetrator was one William Cubbage, who was 82 at the time, a 4-time previously convicted sex offender who had been convicted of his crimes when he was in his 50s, 60s, and 70s. After he served his time for his 4th and final conviction, he was committed under Chapter 229A of the Code of Iowa as a sexually violent predator who could not or should not be released into the population at large. He was kept at the sex offender unit of the Cherokee County, or the Cherokee Mental Health Hospital for 8 years. After 8 years, the folks there at Cherokee decided he should be discharged because, well, for several reasons, but one of which because he did not qualify for what they call conditional release. Principally, he didn't qualify because he never participated in rehab, never submitted to treatment, never repented his crimes, and would not acknowledge that he, in fact, had a problem with his sexual urges. The hospital of the state then moved towards a discharge. They filed an application, actually stipulated an application for discharge. The court signed a discharge order. But before they did that, they filed an application under the hospitalization statute, which is Section 229, and alleged that he was a danger to himself and to others and should not be released. The discharge from 229A was not effective until after the commitment order was signed by the district court judge. The judge noted in his order that Mr. Cubbage should not be released and should be hospitalized for 2 reasons, essentially. One is because he showed some signs of dementia, and the other because he suffered from executive dysfunction, which I'm not sure I understand, but those are the 2 reasons the court cited. Then at the preparation and direction of the state of Iowa, Mr. Cubbage was sent to the Pomeroy Care Center. The state of Iowa had made those preparations before they actually asked him to be sent there and committed there. They had one meeting in Cherokee with the folks from the Pomeroy Care Center, and those folks elected to accept him as a patient. From there, we, after the sexual assault, went through the tort claims process, filed suit against the state of Iowa. After some discovery, the state of Iowa filed a motion for summary judgment. They alleged in their motion, of course, that they had no duty to Mrs. Gottschalk because Mr. Cubbage had been unconditionally discharged. And we filed, of course, our responses, we meaning the estate of Mercedes Gottschalk and the Pomeroy Care Center, both of us filed resistances, filed briefs, attached copies of deposition transcripts. In our resistance, we cited two things, essentially. One is we believed still at that time that the state had not complied with Section 229A in their method of discharge, which we alleged was a violation of the statute. And then we also, in our resistance, alleged that the state of Iowa was still, in our mind, guilty of violations of common law. For instance, we alleged that they failed to warn those folks at the Pomeroy Care Center. And we also alleged that, at least the plaintiff did, that the placement of this fellow at the Pomeroy Care Center essentially amounted to a negligent placement. The Pomeroy Care Center then alleged that there was also a negligent discharge. In the district court's ruling, the judge noted that, of course, that the motion had been filed, and then he heard us. We argued the motion. And then in his ruling at page 2, he said this: plaintiff and third-party plaintiff resist, arguing that the state had a statutory duty pursuant to Iowa Code Chapter 229A and a common law duty of care under the given circumstances. In his discussion, which admittedly was brief, he recited that the statutory claims failed because the state of Iowa had unconditionally discharged Mr. Cubbage. And then he said, and this is his exact wording, further, this court finds no common law duty as defined by prior case law covering the facts of this case. And then a little further on, he cites the authority for that finding, and the authority includes a case called Leonard versus State, which is 491 Northwest 2nd. The Leonard case has some striking similarities to this one in that it was a claim by an injured person against the state of Iowa for having discharged a dangerous person, a mentally ill person, from a mental hospital. In the Leonard court, it was held that the state, in spite of having discharged him, still retained a special relationship, so that, in fact, under these circumstances, they would retain responsibility for the actions of a third party, because that third party, of course, had been their patient. But, and so they found that, in fact, they did have a duty to refrain from a negligent discharge of the patient, but the duty essentially was negated by what is sometimes referred to as a public duty doctrine. That is, when the state owes a duty to the public at large, then no individual member of the public essentially has standing to file suit. And again, that's, at least my interpretation is, that's based upon the concept that the state cannot foresee injury to a member of the general public, and therefore they should not be responsible for the injuries caused by the former patient. The question, I guess, exists now is, in light of Thompson versus Kaczynski, can we still utilize that public duty doctrine in that same framework?
Mr. Hamilton, let me ask you about Restatement Third, since we've now reached Thompson. It seems to me that Section 41 is the applicable section of Restatement Third that talks about an actor in a special relationship with another owes a duty of reasonable care to third parties with regard to risks posed by the other. And then they specifically talk about a custodian with those in its custody being such a special relationship. But then comment F says that that duty ends when the custody ends. So how do you address that, knowing that kind of we've been applying the third restatement a lot recently?
Well, I thought about actually the particular question when I was driving down here, but the as I view it, the state, in my mind at least, has never relinquished custody. They're the ones that arranged for, not his family, no one else. They're the one arranged for his commitment under Section 229. And the surprising thing was that, of course, the court order says he was committed because of executive dysfunction. But we deposed the administrator of the mental health hospital in Cherokee. And we asked him specifically, if you felt that he was not likely to reoffend and felt that he was qualified for discharge, why didn't you just open the door and let him go? He said, we didn't do that because he was a sexual deviant. They didn't tell us that they didn't do that because he showed signs of Alzheimer's. They didn't tell us that because he was suffering from executive dysfunction. They told us that because he was a pedophile, and they considered him still dangerous. So as far as I am concerned, they never relinquished his custody. They just rearranged it. They rearranged it from 229A to 229.
What's wrong with the notion that he was then became in the custody of Pomeroy, and your cause of action is against Pomeroy?
It is, and it remains against Pomeroy. But as far as I'm concerned, they had far superior knowledge of this fellow's tendencies. They had him in their custody and control for 8 years. They prepared numerous reports, and those reports noted that this fellow is incorrigible. He doesn't accept direction. He doesn't accept rehabilitation. He doesn't accept treatment. He won't even acknowledge that he's a sexual pervert. And so, in my mind, they simply wanted to shift him to somebody else's custody just so maybe they didn't have a room, maybe they didn't have money, I don't know what it was. But they never actually surrendered his custody, and if they did, how would that excuse them from a responsibility to warn the folks at Pomeroy Care Center? They specifically hinted, rather broadly, to the folks at Pomeroy that people don't react well. For instance, I don't think that if my mother was in that nursing home, I don't think I'd react very well if I knew that a 4-time convicted sex offender was in the room right next door. So they kind of went out of their way, I think, and I'm stepping on my associate's time here, but they went out of their way, of course, to conceal that information from the folks at Pomeroy. So as far as I'm concerned, they retained de facto custody of this fellow all along.
Yeah, Mr. Hamilton, one question about the de facto custody. There was an independent court order committing this person to Pomeroy. You say de facto custody and control. You help me out understanding the factual basis of this de facto control.
See, if you want to discuss the specifics, for instance, we have alleged actually my associate alleged a negligent discharge.
But that's
Now,
not custody and control.
I know.
Control.
But my point is this, is that the entry of a court order might then intercede to excuse any neglect or malfeasance up to that point. But then they entered an additional order at the state of Iowa's insistence that he be sent to Pomeroy. The statute itself, however, talks about hospitalization. This was not a hospital. And there was no evidence to indicate that these folks at Pomeroy had any special expertise in dealing with unreformed sexual deviants.
I'm not sure I understand the argument that there was ongoing custody and control. I do understand the argument that mistakes might have been made, but at the time of the assault, explain to me why the state had custody and control of him at the time of the assault. Or is that not important?
I'm not sure it's important. final conclusion, but as far as I'm concerned, they again, my whole theory is based on the fact that they had far superior knowledge of this fellow's tendencies, of the risks associated with him. They did virtually nothing to determine what would happen when he was in the custody of the Fonda Care Center. They didn't know how he would be kept away from other folks. They didn't know what the care center would do to protect their own residents. And I'll give my 50 seconds to Mr. Luginbill.
Thank you, Mr. Hamilton. Mr. Luginbill, could you put 4 minutes on the clock, please?
It's a complicated case, but the key in my mind is the matter centers on the duty of care owed by the state when it releases a sexually violent predator to a nursing care facility. The district court held no duty. Once you do that, no duty under common law, no statutory duty.
Counsel, it was more than that, wasn't it? I mean, it was a discharge to a nursing home facility under the specific condition that he be committed there involuntarily.
Correct.
Right? So would it be different? Would it be different in your view? Would you have a harder case if the state agreed to discharge this gentleman with no continuing commitment without a restriction that he be that the involuntary commitment continue?
Our position here is that a special relationship exists between the state and Pomeroy because of the way they handled it. What the state is here telling you is it doesn't matter. It doesn't matter what we did or how we did it. We could have taken this guy and taken him to the bus station, put him on the bus, and let him go. They say we could take this guy, we could set him on the curb, and let him do whatever he wants to do. We could drop him off. That's not what happened. They came to Pomeroy. In fact, this wasn't the first. This is the second time. They said, we got this guy. Come on over. Pomeroy goes over to the state of Iowa. They meet with him at Cusco. The state then comes over to Pomeroy. They talk to Pomeroy about it. We're saying a special relationship exists which creates a duty of care, that these facts are unique.
Is my timing right on this? I've looked at the orders, and it appears that he was committed to Pomeroy on November 16th, but he wasn't discharged from the state until November 24th. I mean, that's when the order came down. So at the time he was committed, and the state made arrangements for the committed. They're the ones who filed the involuntary petition to send him to Pomeroy. He was still under their care because he wasn't discharged till the 24th. Is that right?
I think you're right.
I mean, that's what the order showed to me.
So then the question becomes, can the state orchestrate the process so they can discharge this fella and let him go wherever he wants to go? We're saying the unique facts of this case create a duty of care between the state and Pomeroy, and they breached that duty of care.
If Justice Mansfield's right about this special relationship require them to be in custody, but I think it's Section 41, not 40, that governs this, because it talks about mental health providers to the special relationship between mental health providers to patients. Don't they have to be under the care of the mental health provider for that special relationship to exist?
In my position is that in this case it's unique. I would disagree.
Well, my question is, if that's the case, is that 8 days? You know, when they're making the arrangements, and because 41 talks about warnings, you know, to people who's going to be in their things. Would that 8 day, when they're still under the care, would that get you underneath, you know, they're still in the state's control until they send them over to the institution?
Our position is that when they make that decision, it doesn't matter because there's a duty of care, a common law duty of care when they send him over there. They come over, they talk to us, they tell us he's absolutely no risk.
I'm no longer your patient, you know, that special relationship's gone, and if that special relationship's gone, then all those duties under Section 41 disappear.
We're asking this court to reject that argument. We disagree with it. Thank you.
Thank you as well, counsel. Mr. Thompson.
Please, the court, counsel. Let me just wade in with the discussion of the restatement third. And one of the things we tried to do in our briefing is to acknowledge the Thompson case and create an argument for the proper analysis. And Justice Mansfield, I think you're exactly right. I mean, when you follow the restatement, you go to section 7, you've got A and B, and in our brief we talk about two paths, and one path is B, which is, you know, considerations of policy that permit the court just to say no duty. And we really haven't made that argument, although there's an argument that I think the Court of Appeals latched onto, that you can view some of our public duty doctrine cases like Leonard and Ross through that prism, and that was the basis of the Court of Appeals decision. We think that's perfectly valid, but
Aren't those cases, though, really trying to cabin the universe of potential plaintiffs? So in the mental health field, you know, we limit the liability of the mental health professional to the universe of folks for whom the treatment provider has a reason to expect there's a risk. Okay?
correct.
And so in this case, it seems to me, if as was suggested, you folks had just set him on the curb, and then somebody out there in the public was injured, I might find that a more appealing case to say no duty. The distinction here, it seems to me, is that there's a very small identified universe of potential folks who are put at risk by placing Mr. Cubbage at the Pomeroy facility. And so this case doesn't neatly fit in the public duty and mental health duty realm of cases, in my view. Am I wrong?
No, I think I agree with you. And so my point about Leonard, for example, is that the public policy discussion in Leonard can fit into, as the Court of Appeals did, an analysis under 7B of the restatement third. I think that
But Leonard didn't do it on public policy. Leonard did it on, they said there's a special relationship, but it's not going to go to unknown people. I mean, they didn't say we're not going to never allow it.
It did both. And again, as the appellants have pointed out, that those cases do talk about foreseeability. And that's part of the analysis in those public duty cases, which is why we haven't relied upon them, because Justice Hecht and this court peeled foreseeability out of that duty analysis. And so the proper analysis is to go through Thompson and the restatement third analysis. 7 says broad duty subject to exceptions, and I think Justice Mansfield is absolutely right that where you end up in this case is you go through section 37, you end at section 41, comment F. Justice Wiggins, I think you're right, there's a separate section, section 40, that deals with defining special relationships. Mostly the focus in our brief, in our focus of this case, is on the custody and control issue as opposed to the mental health issue, because that's, as you point out, it's really for outpatients. The Tarakoff case from California is an odd case. But if you go through the standard run of section 41, it's very similar to the restatement second analysis that was done by the courts in Kolb and in Ross. And
I could agree with you, I think, and I don't know if I do, but I think, let's assume I do. The purpose is that once you're no longer treating him, you're done. You know, if you put him out on the street and he went and did something, you're probably done. I mean, I think that's the case. But factually, that's not what happened in this case. Factually, you were still treating him while you were referring him to Pomeroy. So it seems to be more under Section 41 when you talk about that, although it's not outpatients, but it's a mental health releasing somebody to another place.
Sure. Well,
And 41, the only duty under 41 I can see is that when you do that, you have to warn the people where you're releasing him. And 41 talks about that.
well, and it again, but this is where it matters what claim we're talking about. Okay, so what we heard a little bit of discussion about preservation in the district court, but there's this kind of broad range of allegations that have been made There's only a handful of allegations for which error has been preserved, and of those allegations, only a smaller subset of those have been argued and briefed on appeal. And so the issue that the district court decided, and that is before you today, is an issue that relates solely to things alleging a duty that would have occurred after the unconditional discharge order.
I understand your position that it wasn't preserved, but if the duty to warn when you released him was preserved, how do you avoid liability under Section 41? Because he was released to that institution while he was under your care.
Right, and I would argue that, number one, I want to back up to something you asked counsel about, and you are absolutely right, there's an overlap in the orders. In other words, one of the kind of misnomers of this case is that at CUSA they just decided they were going to release William Cubbage. This court has done cases on 229A. The record is clear that the reason Mr. Cubbage was going to be released is because we couldn't keep him anymore. That the evidence-based record in this case is he no longer met the really high standard that this court has said we have to meet in order to keep somebody civilly committed at the SVP unit.
How did he not meet the standards?
Well,
I
because
assume all the reports up until that moment when he was unconditionally discharged said he continued to be a threat. He still had the mental diagnoses, and he still continued to be a threat to reoffend. And I assume every report up until the immediate time of his discharge would have simply confirmed that. Otherwise, you couldn't have kept him in there.
That's not
and
true.
So, well,
And
that's
so let me point you to the record.
And maybe
then.
that's the problem with going back to the discovery problems, is that we don't have copies of all those reports in the record. We don't know what this history is. You're telling me something that maybe it's in the record. I haven't had the time to look at everything, but you're telling me something that, oh no, we just couldn't keep him anymore, so we gave him an unconditional discharge, which doesn't seem to make sense to me.
There's three things in the record that you should look at. Number one is there's a 90-day review, which they do every 90 days, obviously, done in May, where the doctor talks about the issue of both his advanced age, the fact that he has dementia, and because he's now 82, and if this court has looked at the standards that we have to rely upon in order to meet the likely standard that everybody talks about is a defined term. So likely means more likely than not, based on clear and convincing, actually beyond a reasonable doubt. And so there's a 90-day report. There's the annual report, which then followed. That's dated in July, I believe, which reaches the same conclusion. And then there's the testimony of Dr. Ryan, who explained that in addition to the clinical presentation and his age and his dementia and his need for care, is that because of his advanced age, the statistical models that predict recidivism wouldn't support the argument that more likely than not he was to reoffend. And so I want to go back to your point, Justice Wiggins, which is the irony here is, and I think you're agreeing, that if we had just discharged William Cubbage and wheeled him out the door like you see in the movies, no duty. But what we engaged in, and this is very important.
If you let him out the door and weren't involved in his commitment, I mean, there's a two-prong there.
Well, I agree, but this is why, this court, in adopting the restatement third, has said public policy is something we talk about, both in duty and in these exceptions, is that we engaged in responsible discharge planning. This is something that the corrections and MHIs do all the time. Every day people walk out of these institutions, we work to find a place for them so they don't just get released into the...
And I think Section 41 takes care of you there, because as a defense you could raise. It's called the good faith decision by the physician and what they did,
Right.
and they equate it to the business decision rule in the corporate world. I mean, that's a defense, but it's not a bar. Now, I will give you, 41 does say you can accept a public policy exception. But I don't think we did it in and I can't think of the name, the case that Justice Newman wrote. LeMaster. I don't think we did it by public policy there. I think we said if there's a special relationship, there could be liability. And if you read Lemon versus Freeze, which I don't think anybody cited, we actually said the same thing years and years earlier. But there is a special relation, but we're not gonna do it to the general public. So I don't know if we didn't adopt it back in those two cases, why should we adopt it here?
We agree. I mean, we have agreed in the briefing that while he was at CUSO, we had a special relationship with him. Okay, the conduct that's being complained of occurred 9 months afterwards. And so the question is, in this 7-day window between November 16th and November 24th, in which he was unconditionally discharged, what is it that we did?
But you unconditionally discharged him after you committed him. And you made that's what the facts show, I think. And,
That's absolutely correct.
and the problem I have, and I don't know what the answer is.
Right.
I really don't, because this is really a strange case from factual-wise to apply to this law. But the problem I see is that you had that special relationship when you went to Pomeroy to get him there, and then had him committed under 229, whatever the section is, and told those people, allegedly told those people, he's not a threat to other patients. And
Well,
I mean, that's a
and-
factual question. I don't know if that's true.
Well,
or
I
not.
guess it is, but you can look at another thing. You've got 2 court orders, as Justice Apple pointed out. We not only have the committal order that was signed by a judge, findings of fact saying he's a threat to himself and others. It's in the order. Pomeroy did not reject. He even commented in his opening statement that Pomeroy agreed to take the referral. He was committed by a judge.
That's another issue under 41, which is another factual issue. Do you have a duty to warn if they know of his condition?
We
And that's-
warned, it's undisputed.
And, well, they say you said he'd be no threat to other people, and then there's this nurse's testimony or psychologist's testimony
Who
that say,
also-
we wouldn't release him, and I mean, I gotta read the record, but it
Yeah.
seems it's a
Well,
factual
and
issue there.
They also it's undisputed that they had previously had a sex offender. It's undisputed that they had the records that I've told you about. The annual report and the 90-day report was in Pomeroy's records, so they had everything that you're talking about. In fact, everything that they quote as having this inside information. Pomeroy came to CUSO, they interviewed Mr. Cubbage, they got the information, and they agreed to be the recipient of a 229 order signed by a district court judge in Cherokee County.
I want to just continue this discussion about the duty question, and maybe from a little bit different angle of analysis. We speak of special relationship as a foundation for duty in circumstances in which the Section 7 general duty doesn't exist. Why wouldn't this suffice as a basis for a special duty? First of all, we speak of an unconditional discharge. I suggest and invite your response that that's a bit of a misnomer. The discharge really was with conditions. It was with an agreed upon condition that he would be involuntarily committed under a different statute. So we can call it an unconditional discharge, and maybe that's what the order says. But really, would you agree with me that there was a condition to the discharge in that sense?
well-
That you weren't putting him on the curb to walk away?
Well, indeed, because
Right.
we didn't think that would be
Exactly.
a derogation of our duties to the public
Right.
and to Chapter 229. So I think there's, I mean, it's easy to throw this all in one basket and say the
Right.
state's the state.
So-
as
so let me-
counsel's trying to do.
my
Okay, well,
analysis.
I was going to answer, but.
Okay, all right,
go ahead.
so I think we agree on that point. A special relationship in a mental health context can come up where there's an ongoing treatment relationship between a provider and a patient. One could question whether there was any treatment going on in this situation before the discharge or after, because he didn't cooperate in treatment. But that being, putting that aside, if we don't view this as an ongoing treatment scenario in which a special duty could arise, why wouldn't we view this as a circumstance in which there was continuing control? And here, let me tell you what I mean by that. The agreement was we'll discharge him from SVP treatment on the condition that he's placed in this other environment. We have an agreement that involves both the state and the Pomeroy Care Facility. It almost appears as though there's continuing control, and that you might say, and I invite you to push back, that the Pomeroy Care Facility in effect becomes the state's agent in the continuing control of this person known to still be dangerous. What's your reaction?
Well, I guess first I ask, would that be your argument as to every 229 order signed by any district court in Iowa, or is this unique to the facts here? Because every day, again, courts commit people for mental health care to hospitals, to nursing homes. And so in this case, I think it's not continuing because there is a difference. There is a physical difference. There is a legal distinction between the sex offender treatment program unit at CUSO, which is subject to a very rigid statutory framework that this court is very familiar with, that has constitutional restrictions on it, that Mr. Cubbage has rights too, and that's one of the issues here, is we can't keep him. We were not going to keep him. No, we couldn't keep him because he was entitled to release. It's easy to forget, Justice, that he was represented by counsel in this. So he had a court-appointed lawyer who was at the table and who was negotiating to get his cares, his client's needs taken care of so that his treatment for his list of medical issues, which is also in the report, separate from his mental abnormality and his pedophilia, he was very, very sick man, and he was going to and from the University of Iowa in order to get treatment. This man needed treatment, and that 229 order put the legal responsibility of care, custody, and control of William Cubbage on Pomeroy, not on the state of Iowa, not on the CUSO program, and that the discharge order was a legal step that took him out of an institution that he had been involuntarily committed to for 10 years of his life and cut the chains unconditionally pursuant to the law. So he's no different, and this is why we look at Ross and these other cases. Mr. Cubbage was no different than an offender in one of our state institutions that serves his sentence or her sentence and is entitled to go free. And we don't guarantee their behavior going forward. And so if you start going down this line of this is just, a continuation and extension of a criminal sentence or a civil commitment under 229, I believe it's a really, really dangerous thing, Your Honor. And I think that one of the things that Restatement 7 does is say public policy is one of the things you can always consider. Would we be, under this scenario, we're better off putting these people on the street corner. That's a ridiculous legal result. That if we engage in discharge planning, we take on some kind of tail of liability that's undefined, and that can't be the law. And I don't think that Restatement 3rd, Section 41, if you just follow the path, leads to that result, because control is the key. I mean, as you said in McFarland in your dissent, and Justice Waterman said in the majority of the opinion, one of the things that you guys agreed on, one of the few things, was that liability should follow control. And Mr. Cubbage, when this event occurred, was under the care, custody, and control of Pomeroy Care Center. And I'm way over my time. Apologize.
Thank you, Mr. Thompson. Mr. Hamilton, you may give your rebuttal.
I'm going to interrupt you before you start your rebuttal here. I have another problem, and I think Mr. Thompson brought it up about preserving this issue at all, because when I read your petition, you claimed your specifications of negligence were subsequent to placement. DHS should have prepared and approved a safety plan. Your second specification was subsequent to placement, the state should have inspected and determined if there was a proper safety plan. And your third one was that the state cut funding to the nursing home oversight, and that led to this, which I don't think anybody really argued. And the cross-claim only had 3 specifications: failure to supervise and monitor Cubbage while at the home, which is subsequent to his release. negligently represented prior to admission that coverage was no longer a risk to society, and then negligently represented no longer a risk to elderly victims. So the last two were negligent misrepresentation cases. None of these fall into section 7, section 40, or section 41 of the restatement third. So how are we gonna go outside these allegations and try to find some kind of duty or special relationship with the way the case is presented to us? In other words, why was the Court of Appeals wrong that it wasn't preserved?
Appendix page 8, the Iowa Department of Human Services failed to warn the residents that a sexual deviant was living among them. A failure to warn claim. That was the attachment to our petition. So it was one of our specifications of negligence.
That was in the state tort claim, wasn't it?
Yeah, but it was attached to our petition, made a part of it, and of course, I would assume that that would be an allegation that is incorporated into the petition itself.
And the question becomes, where did the district court rule on that?
District court ruled on it when he said that there was no duties under common law, and our common law claims included failure to warn, negligent discharge, and negligent placement. Those were all presented and argued at the district court level. And again, the judge could have been more expansive, but he says, further, this court finds no common law duty as defined by prior case law covering the facts of this case. So
Try and simplify, this a little bit. I don't know if I'm on the right track or not. I mean, it strikes me that to the extent you or Pomeroy are complaining about anything the state should have done after the transfer took place, that restatement 41 is a significant problem. If you're talking about the actual transfer process, there's, I guess, some contention that the state overstated or misstated the extent to which Mr. Cubbage was a threat or not. If that's the case, why isn't that barred by the exclusion that Justice Wiggins alluded to for negligent misrepresentation claims? In other words, everything after November 2010, there's no duty, and the transition in November 2010 is barred by the negligent misrepresentation exclusion, even assuming you preserved error on everything.
the facts would show that the discussions between the state and the nursing home occurred before he was discharged, probably a month or two before he was discharged. So,
Granting you that.
I'm sorry?
I'm assuming that.
Yeah. And that he then was discharged in, was it August? November 24th of 2010. So I submit that the negligence that occurred with the state of Iowa actually occurred prior to his discharge with respect to negligent placement.
But doesn't the State Tort Claims Act provide that you can't recover on a negligent misrepresentation theory?
I understand that, and I'm not suggesting that we're relying on negligent I'm not relying on negligent misrepresentation. I didn't even plead it, as a matter of fact. Pomeroy pled that. But I don't submit that everything that occurred in the course of that meeting between those folks is necessarily reliant on misrepresentation. Failure to they didn't even inspect the nursing home. There was no discussion about, between the state and the nursing home, what are you going to do to protect your residents from this particular fellow? Were you going to alarm the rooms? For instance, after this occurred, the nursing home went to a 15-minute check watch of Mr. Cubbage. They went and looked at where he was every 15 minutes. They put an alarm on his room, so if he left, the alarm would go off. They had videotapes. I mean, they had all kinds of protection methods after the fact, but not before. And although the facts are somewhat in dispute, there was no specific discussions about these systems beforehand because, as you'll note in the record, the state of Iowa went over there after the assault occurred. And then they said, well, what did you do to protect the patients? That's what the state asked the nursing home folks. Couple things quickly. Counsel for the state was talking about what they call a 90-day patient assessment in May of 2010. I'd just like to note that it says, quote, "It was agreed jointly that the best avenue for Mr. Cubbage would be to place him in secure care for the rest of his life." This is pending DAS director's approval. The Pomeroy Care Center was not secure care. In the actual 90-day annual assessment, the state says he was a sick man. He was going to Iowa City. He was going to Iowa City because he had some macular degeneration in one eye. That doesn't make him a sick man. In the actual report, I'd also like to mention that the author of the report never met with Mr. Cubbage. As far as we know, he never saw the man. He relied on a report written in 2006 by a different psychologist. He notes in his report that the studies that he relied on with respect to age could not make any determination how a person's advancing age would impact his libido or urge to sexually offend. So there's no suggestion in here, no reports, no evidence that because he was now 82 that he somehow forgot that he was a sexual offender.
Well, counsel, along that line, I'd like to give you an opportunity to respond to Mr. Thompson's argument about the public policy justification for a no-duty rule under the circumstances here. To summarize, I think, his argument, he says, you know, we couldn't continue to keep him at the SVP unit under the circumstances. This guy wasn't somebody that should be turned loose out in the public, and so we took a reasonable measure to try to get him committed so that he wouldn't be out in the public. And so for public policy reasons, you shouldn't even hold us to a duty.
Mr. Hamplin, you may respond and then sum up your argument.
He was being held at the Cherokee Mental Health Hospital. I've been through some of those involuntary processes before. And the hospital referee or the judge entertains the application to have a commitment. There is an examination by a psychologist. And then if the judge finds it necessary to commit someone in Cherokee, he commits them to the Cherokee Mental Health Hospital. He doesn't commit them to a nursing home. This is a hospital statute. It talks about mental health and hospitalization. But the state did not send him back to the Cherokee Mental Health Hospital. They arranged to put him in a nursing home some 50, 60 miles away. Why wasn't he committed to the Cherokee Mental Health Hospital where they have professional psychologists to treat folks with mental health issues? They chose instead to send him to a nursing home that has no expertise in treating people with ongoing severe mental problems. So I understand the public policy involved, but the public policy in this case doesn't make any particular sense with respect to why he was sent where he was sent. So we believe that created an additional risk, obviously, because the folks at the Pomeroy Care Center did not know he was a 4-time convicted sex offender. Just to sum it up, Your Honors, we believe that the decision of the Court of Appeals should be reversed, the case sent back for trial, and that the state of Iowa should, of course, be included in that process. Thank you.
Thank you as well. The case is submitted. We'll now hear the arguments in State versus Coleman.